I'm Ben Meiselas from the MeidasTouch network. Donald Trump was too scared to file an appeal to the 11th Circuit Court of Appeals order ruling that Judge Eileen Cannon should never have asserted equitable jurisdiction in the first place and directing that Judge Eileen Cannon dismiss the case. The 11th Circuit Court of Appeals came out with their order on December 1, and under the appellate practice for a mandate to issue, in other words, for the order by the 11th Circuit to become effective and be transmitted to the lower court, the District Court of Appeals, the mandate, it's the process I just described, takes 7 days by law. Within those 7 days, Donald Trump had the opportunity between December 1 and December 8th to take a number of steps if he wanted to challenge the 11th Circuit Court of Appeals ruling. This is what he could have done. Number one, he could have asked for a rehearing or asked for a reconsideration by the 11th Circuit Court of Appeal panel. Number two, he could have asked for what's called an en banc, spelled E-N space B-A-N-C, an en banc hearing, meaning for the entire 11th Circuit Court of Appeals to hear it. They would first have to grant the ability to go before an en banc panel, and then the en banc panel would make a determination on whether or not the smaller panel, the 3-judge panel, which typically hears a appeal, whether that was a valid ruling or not a valid ruling. And it's not all that frequent that an en banc review is granted. Or Donald Trump could have done what he previously did when he didn't like the 11th Circuit Court of Appeals order, which is to file an emergency application to vacate the ruling of the 11th Circuit Court of Appeals with the United States Supreme Court. Emergency applications with the 11th Circuit Court of Appeals are heard by the supervising justice who supervises the emergency applications that come from the 11th Circuit Court of Appeals, Justice Clarence Thomas. And Donald Trump decided not to file the emergency application there as well. What you may recall previously, when the Department of Justice filed their emergency motion for partial stay a few months back to return the 100 classified records. To be specific, it was 103 classified records, top secret, sensitive, compartmented records that Donald Trump had stole, which was part of the search warrant that was executed at Mar-a-Lago and obtained, and that the corrupt Judge Eileen Cannon put those documents as part of the special master process. The Department of Justice was like, whoa. Look, we think you're wrong on everything, Judge Eileen Cannon, but 11th Circuit, immediately we need our classified records back. The 11th Circuit agreed with the Department of Justice, granting the Department of Justice's motion for partial stay, returning the 103 classified records. Donald Trump ran to Clarence Thomas, the supervising justice over the 11th Circuit. Clarence Thomas then submitted the question to the full Supreme Court, and in a unanimous decision with no notable dissent, so that's how we know it was unanimous, the Supreme Court rejected Donald Trump's emergency application to vacate what the 11th Circuit did. And so here Donald Trump could have done what he previously did, but I think that his lawyers were telling him, you are going to lose again, and all of this losing is problematic for you. And whereas you are a big loser, Donald Trump, and in the past, losing is part of your brand, and bankruptcy, losing, bankruptcy. The difference here, though, is that your criminal exposure right now is massive. And so if you keep pissing off the United States Supreme Court with your frivolous motions, with your meritless emergency applications that you keep on losing, if you need the Supreme Court for these criminal investigations, save your cannon fodder, if you will, save that for when you're criminally indicted, and then you want to file emergency applications with the Supreme Court, where you're going to lose again. I mean, to the Supreme Court's credit, And it's hard for me to say that because this right-wing Supreme Court has made a number of very, very, very horrible, disastrous rulings that I think are completely against the Constitution, taking away people's freedoms, most notably in the Dobbs decision, taking away a woman's privacy right, taking away the constitutional right to choose. The Supreme Court, though, has gotten it right, mostly on Donald Trump related issues, right? Whether it was requiring that Donald Trump's taxes and financial documents be turned over to congressional committees, whether it was these other insurrectionist related cases, whether it was the documents at Mar-a-Lago and his emergency application regarding the 11th Circuit, the Supreme Court has ruled against Donald Trump time and time again on essentially all the cases that Trump has brought. So what I think is going on behind the scenes here, why Donald Trump was too scared to appeal the 11th Circuit Court of Appeals order and not try to delay this anymore. I think that he realizes that the lawyers who are advising him are telling him, you are going to lose. You're going to piss off the Supreme Court. You are likely going to lose in front of the Supreme Court if and when Jack Smith indicts you. But if you keep losing in front of them, you're just going to piss them off and just lose any ability of any one of those corrupt Supreme Court justices to try to advocate for you in the future. So I think they saw the writing on the walls. I also think that one of the issues probably that happened as well, and I'd love to know what you think about it, Jim Trusty, Donald Trump's lawyer, who showed up before the 11th Circuit Court of Appeals, was utterly humiliated and embarrassed when he gave oral argument. Like, the 11th Circuit Court of Appeals, ate him up. And they were asking him questions and he couldn't answer it. And he was rambling and doing all of this word salad. It was a humiliating court appearance. And I was glad to broadcast that humiliating court appearance here on the MeidasTouch network, where it's been viewed hundreds of thousands of times. More people watched the 11th Circuit Court of Appeals full oral arguments here on the MeidasTouch network than in any other forum. But I think that Trusty was like, I'm not following this. The other lawyer that Trump could have had file it, the only other serious lawyer on Trump's team, is a guy named Christopher Kise. And you'll recall that Christopher Kise is the one who took the $3 million from the Trump Save America grift organization that is also being investigated by the Department of Justice for potential crimes. And Christopher Kise is also the Venezuelan foreign agent, literally works for the Maduro regime. He had to file a foreign agent registration act statement saying that he's working for the Maduro regime in Venezuela. Christopher Kise is like, I'm not going to file it. And so then you had Trusty and Kise likely saying, we're not filing this, because I still bet you that Donald Trump was saying, file this, file this, file this. And Trusty and Kise probably said, we're not filing this. So then you have Alina Habba, Christina Bobb, and I think it's Lauren Hannigan, are the other lawyers. And, I don't think that not only are they not capable of filing it from a legal perspective, I don't think procedurally they would even know how to file the emergency application. And I think Trump realized that whatever they filed would just be so humiliating, even if they tried to figure it out, how to even make the filing, that just don't do it. And let's just take the L. So I think that's what was going on behind the scenes. You could pretty much deduce that based on what took place, what transpired, why this wasn't filed, how Trump usually files frivolous things. But, the headline here is Donald Trump is too scared, too intimidated. It's different, right? I mean, things feel different right now with the Trump Organization convicted in New York and by the Manhattan District Attorney's case, with the pressure right now that's being applied by New York Attorney General Letitia James and her fraud lawsuit seeking at least $250 million in financial penalties and an injunction to break up and stop the Trump Organization from doing business ever again in the state of New York, with what's transpiring in Fani Willis's special criminal grand jury in Fulton County. Of course, what's going on with Jack Smith, all of this, and this decision here of Trump not to appeal, which goes against all of his prior conduct. also is an indication that things are changing. Things are different right now. And we will be covering it here on the MeidasTouch Network. We're going to have a very busy 2023 together. So happy holidays, happy New Year's. Don't worry, we're not going anywhere. We'll be here throughout the holidays. We'll be here reporting for you, with you throughout this time period. And we're going to have a busy 2023. So get ready and subscribe to the MeidasTouch Network. And do me a favor. This could be your holiday present for me. Share this video and share the MeidasTouch channel with as many people as you know. Maybe do at least 5. If you can get 10, if you can get 20, if you can get more than 20, I will be so grateful, because we need to grow this independent media network, and we need to spread the word about real news, real analysis that's not being done anywhere else. We so appreciate you. And consider becoming a patron of the MeidasTouch Network by going to patreon.com/MeidasTouch. It's a membership over there where you'll get exclusive content, but most importantly, grow this independent media platform. We're not funded by any outside investors. That's the one way you can help us grow. Patreon.com/MeidasTouch. Thank you so much, and I'll see you soon.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.